isn't the biggest inconsistency at the moment a scenario where two young people of the same age commit the same offence? One is dealt with through the children's hearing system, one is referred to the criminal justice system. It could take up to 2 years because of court delays for the person who's going through that to be dealt with, by which time the other one has been dealt with, perhaps been rehabilitated and gone to a more positive kind of outlook. Is that not the greatest inconsistency here?
That's a possibility. And it's a possibility that can arise for a number of different circumstances. But if you're talking about two 16 or 17-year-olds, one of whom is on a supervision order and one who's not, then we would discuss the case with the reporter and decide for the one who's on supervision and decide who's best placed to deal with that case. But for the one who is not, that option doesn't exist. And so we would look at other options, and we would still have a presumption in favour of, a presumption against prosecution in the adult courts. We would look at diversion or other possible alternatives to prosecution. But there is a possibility that that case could end up in the court. And as you say, the courts aren't operating as efficiently as they did pre-pandemic, and so there could be significant delays, and we could have different outcomes for essentially the same circumstance. I totally agree. Okay, thank you. I just wanted to get that on the record. I wonder if the panel could outline for us how a reporter currently decides whether a child or young person should be referred to the children's hearing system. Just give us a feel for what the thought process is around that and how, if in any way, that might change with this bill.
I mean, I don't think it will change in relation to the bill, because there will still be the same principles and the same approach that will be taken, because we will simply view any child or young person referred to as a child, and will apply the same principles and the same foundation principles that are contained within the Children's Hearing Scotland Act. We would consider all of the circumstances of the child, all of what their living circumstances were, their relationships, what was happening in terms of any education, if they're of education age. We might obtain reports, we might investigate and obtain information from partners in social work, at school and health, other partners who may be involved with the child, all of which to identify what the child needs in order to support, sometimes to protect them. But ultimately our conclusion has to be, in order to refer to a children's hearing, that compulsory measures of supervision are necessary.
But even with that framework, I guess the reality is that there's always a degree of subjectivity in the decision-making that takes place, and it must leave you open on occasions to accusations of a lack of consistency, perhaps unfairly, given everything you've got to take account of.
Any children's reporter who joins the service has to go through the Professional Development Award for Children's Reporter Practice, and there are 7 modules within that. It's been SQA assessed at master's level. So, and they have 2 years within which to complete that. Otherwise, they will not become a children's reporter. Decision-making is one of the modules within that Professional Development Award. What we also do is we have our own quality assurance. So we do our own case sampling constantly, and we interrogate and interpret whether we believe the right decision has been made based on the information that we have.
There was recent research by SCRA and the Fiscal Service into children aged 12 to 15 involved in offending and referred to the reporter and the Procurator Fiscal setups in Scotland. So I wonder to what extent that has indicated a strong link between those children who come into conflict with the law and the degrees of adversity, trauma, poverty and loss that they've experienced. And if we take account of your experience personally in dealing with these things as well, beyond the research. Do you want to go first?
I think you could probably say there's absolutely a kind of close correlation there in terms of children who come in conflict with the law, in terms of from a kind of Police Scotland perspective. We do not only deal with and refer children to the reporter in relation to criminal cases, but more often than not, it is in relation to welfare, and I think that's why this change is really important.
Do you not accept that sometimes it appears that the victims and their families are kind of forgotten in all of this?
Our view would be that there's a need for more resource for victim support, absolutely, but not at the expense of support for children who are in conflict with the law.
And I don't disagree with that. Perhaps I haven't made myself clear. You very often find that the victims and their families are looking for reassurance of what measures have been taken to protect them. And it's impossible to get that information, and the grounds that are provided is that these are matters that pertain to the alleged perpetrator, and we can't share that information, which just exacerbates that sense of concern about the victims and their families. That's what I'm getting at here, and I don't have the answer to it, right? But I just want to get a sense that you recognise that this is an issue.
It is an incredibly difficult balance, and it would absolutely, it's not, to an extent, not something we can legislate for, because it actually is, it's a case-by-case decision around safety planning for individual children who are in communities.
If you watch the earlier evidence session, we looked at the inconsistencies in the experiences of 16 and 17-year-olds. Any other inconsistencies that you would want to make us aware of in relation to the current situation?
Yeah, I think there's also, as we've spoken earlier, that children on welfare grounds, so can't currently access the children's hearing system unless they're already an open case or on compulsory supervision prior to the 16th birthday. So
the bill provides that where a child is to be deprived of their liberty, no one under the age of 18 can be committed to a prison or a young offenders institution. They would instead enter secure accommodation or similar residential establishments. I think we would all welcome that move. But are there any concerns that you have around moving to that setup, perhaps around capacity?
So there are things in place to look at capacity, but our secure care providers, and I'm sure you'll hear from them at some point, what they provide within secure care to meet the needs from the sort of care and protection needs, as well as the, the educational, the health, and they can meet the whole sort of plethora of what is needed for children who are and are most traumatised and children in society.
And would you accept that, of course, there's a balance to be struck here in between the need to provide environments which will help rehabilitate and assist these young people, while also giving the public confidence that they are, depending on the offences they've committed, in genuinely secure accommodation?
Mm-hmm. Yeah, and I mean, the secure care centres are secure.